you go forward with your sentencing with your present, Mayor?
Allah Saikharai, the Most High Judge, the all-knowing one.
Okay.
Ask me.
Thank you. You can review.
Okay, come on, man.
Whoa! They're busted! Get out! We're coming in! Get out! Stay right here! Oh yeah, we're coming in! Oh yeah!
All right, for the record, Ms. Cook, in the past, has been able to participate in the proceedings. She actually assisted Mr. Origin both in jury selection and during the trial. She knows how to behave. And as we've gone through before, we believe that she is malingering. I am still of that opinion. Mr. Origin, are you still of that opinion?
Yes, Your Honor, I believe she is still lingering in all the circumstances. She has assisted me throughout the trial. She assisted me in jury selection, as you said. We were productive for the most part, but like you just said, lingering, and this is all.
And so, go ahead, Ms.
Can I just
Mazzoni.
add one thing?
Yeah.
One of the things that she said here today is she called it a 4-day.
She corrected the amount of days.
Right, she knew how many days it was, and there are little things that come through that show that she actually does know what's happening. So I just want to pick that for the record.
Nope, I appreciate that because I noticed that as well. All right, then we will proceed with the sentencing. We will do it as if it is voluntary on her part to not participate today. But she was present at the outset, and I did inform her again of what the verdict was. You all have received the pre-sentence investigation report. I have reviewed it as well. And so, Mr. Origin, is there any legal cause why sentence should not be pronounced at this time?
No, Your Honor.
Okay. As a result of that,
There is going to be one issue. I don't know how I'm going to have her declared indigent for appellate purposes. Yeah, there needs to be an application.
probably gonna have to go see her in jail and see if you can get
She will not, it's been unproductive. They will not bring.
Okay.
So I think we may have to do
We can do a separate hearing if you need to. You can bring her back.
today or some other time.
Yeah, today or tomorrow, so that give her a chance to calm down.
Okay.
If we need to, we can do that.
Oh, listen.
Okay.
we've been together since a year before this happened, and we were married at the end of last year.
When I got the phone call, I didn't believe it. At first I thought it was some sick prank call, and he thought so too. So, it did impact my life a lot. And it still does. And I do have immense anger, and I pray that I will be able to forgive this monster someday. But my mom would not be a threat. I was with her every day. She was all I had. We were mother and daughter. We were also best friends. The only person, and she maybe babied me a little bit. She maybe, took care of things that I should have learned. Yeah, so it's been kind of hard without her because that's my familiar, and I'm a little blown away, by, how the system works and everything. But, I understand, and I'm very grateful for, everyone who has been helping, get justice for my mom. And, very grateful for my aunt for being in my life. And, we've gone through the same exact thing. She lost her sister. I lost my mom. Two kinds of different relationships, but still very important relationships. Family. That's, and I don't really have any family, and, I mean, I do, but she's in New Jersey, and, yeah. I thought I was gonna be a little bit more strategic up here. Thought I had it all together. And then I got up
I
here.
can fill in for you, Your Honor.
It's okay.
Basically, before I met her, she had solved some problems in her life, and her mother and her were on the way to making her better. She wasn't an independent 30-year-old when this happened. She was totally dependent on her mother. And even after we got together, she spent a lot more time with her mother than she did with me. This was the biggest impact in her life, and I'll tell you in a minute how big. She almost went back to her old ways, and I actually had to Baker act her. They put her in NCH lock ward because she was so distraught over the loss of her mother that she wanted to die and join her. That is how desperate an impact this has had on her. And luckily, we moved forward. She's stayed in a good path, but she would be in a lot better place today if it weren't for this. Her and her mother would have put her much further ahead than she is now. There's only so much I can do to help her in these circumstances, and all she really has is her aunt that's in Philadelphia, right across the river from Philadelphia, New Jersey.
Nice.
Anyway, and myself and her mother was gone, and it was such a horrible thing, and it had a dramatic, almost fatal impact on her. And I knew her mother before I knew her because she was a realtor in one of my estates that was particularly quarrelsome and violent. And she always approached that with kindness. Even though she was on Social Security disability, she was spending her time helping a lady who was dying of cancer, helped a couple of my clients that I sprung from Baker Act facility and got back to their family. That's all she did with her life, was take care of her daughter and help other people, even though she was dramatically disabled and could not have put up a fight. And in any event, she always had the pacifist route. This this is a horrible thing that has happened, and part of my job during the trial was to make sure her and her aunt didn't see any of the things from the medical examiner. But I did observe her when she saw them, and there appeared to be absolutely no emotion, no remorse whatsoever. And this, as you know, Your Honor, is one of the more violent deaths we've had here in a long time. And I believe that she is smart, evil, and unrehabilitated. And I've only been an attorney for 43 years, so I don't know anything. But she, I believe, is a danger to society. Before this happened, she was Baker acted 4 times and should have never been out really without, she's definitely competent to stand trial, definitely participated here with her attorney. And we've been through this for now 6.5 years. And I've been there since the arraignment.
I moved her finger out of my mom's face, and she dragged me by my hair, and then when I saw some pictures, I really didn't know. He's in the same spot,
And
and she has no remorse.
what she just described happened in front of her mother. And her mother's reaction was, don't do anything, don't hit her, don't fight back.
Oh, and
That
I
was
said,
Karen.
Mom, I promise. She said, because they'll come arrest you, and I don't want that.
That was Karen Lighty. She was a totally nonviolent
Scared
person.
that I would get in trouble because of my past with like little,
No, that's okay. Anyway, all right, thank you, Your Honor. I apologize. And
You don't have to apologize, Mr. Rankin, you did fine.
And, I'm doing the best I can, Your Honor. As you know, there's a statutes and a constitution lets me be here, but they've never rewritten the criminal rules to take me into account. So I've been very, very careful and stayed out of everything. In fact, I talked to the rules committee about doing that, and they declined. So here we are.
All right, thanks, Mr. Rankin. Thank you very much, man. I'm very sorry.
thank you so much, Your Honor.
Awesome. Any other impacts?
No, Your Honor, no other impacts.
Mr. Gordon, any mitigation you want to present?
Oh, sorry, sir?
Any mitigation you want to present?
No.
Okay. No, that's fine. So a couple things I wanted to clarify, excuse me, that I missed earlier. In the pre-sentence investigation report, it does mention that Ms. Cook refused to participate in the pre-sentence investigation, and Ms. Cook was correct when she said it was a 4-day trial after I said it was a 5-day trial. The record, day 1 for me, which was day 1 of day 5, was the motion to dismiss on the stand your ground, which we spent all day together on that Monday, and then we did 4 days of trial, so she actually was correct. It was only a 4-day trial, but for us, we went 5 days.
Right, which shows like a deeper understanding of what happened that week, on her part.
Is why I'm putting it on the record. So, okay. All right, so, State, what are you asking for?
Your Honor, the state is asking for a life sentence, as well as cost of prosecution in the amount of $1,817.47. And I would also ask the court to order and reserve on additional cost of prosecution. We still have some invoices that are coming in and need to be cleared through our office.
Okay.
I can
And Mr. Gorgian, what are you asking for?
I'll ask this on, Your Honor.
Okay. All right, do you have the score sheet?
I provided you a copy.
You did, sorry, it's sitting right next to me, I apologize. Okay. So, stand for cost of prosecution. Should be cost of prosecution. So, as we started, Ms. Cook was found guilty by a jury of her peers on December 12th, 2025, in case 19 CF 1306. As has been referenced here today, this case has taken a long time to get to this point. It's taken a long time to get to this point because of a series of issues with Ms. Cook's competency, both becoming incompetent and then becoming competent again. As we got to trial, we determined that she was in fact still competent, which is why we were able to finally go forward with the trial. Rankin referenced in this case that this was one of the worst murders we've had in Collier County in a long time. I would agree with that. This was a heinous act, and it was made all the worse by the fact that after the murder was committed, Ms. Legge was abandoned to die while Ms. Cook went to go visit her mother. And then thankfully her mother came to help so that we could call the police and get help for Ms. Legge. Fortunately, it was too late for that. But Ms. Cook also refused to assist in trying to resuscitate Ms. Legge, which again makes it a worse issue for us. As I have mentioned at the beginning, I will mention again, I do believe that Ms. Cook is competent to stand trial. Ms. Cook has participated in our proceedings. She was assisting Mr. Morrison several times throughout the proceedings, even as she tried to demonstrate that she was not competent to proceed. I believe that was all an act, as I believe what happened today was an act as well. I believe Mr. Borgia is correct that when she came out, she wanted to put on a show for the audience, which is also wrong and sad. But my job here is to sentence her. So on count one, she's previously been adjudicated guilty by me on December 12th as a result of the jury verdict. On count one, second-degree murder, which with the aggravator becomes a punishable by life felony, I will sentence her to life in prison. There's $415 in court costs. There's a $1,817.47 cost of prosecution. I will reserve jurisdiction to determine any additional amounts on the cost of prosecution. Is there anything else that I need to pronounce for this sentence?
Your Honor, can you also order and reserve cost of investigation in the sheriff's office? I was trying to find the number I put in, so I'll have to reach out to the detective.
That is not a problem. I will order and reserve cost of investigation. We can have a later hearing if necessary on that. I have reviewed her score sheet. It does appear to be appropriate. At some point, we will need to take Ms. Cook's fingerprints, Dr. Smith. You can probably do that in the jail for us. But I don't know, you guys can figure that out. If it needs to be back in the courtroom, let me know. We'll develop a process to do that. Mr. Gorgian, on the costs for appellate purposes, if you need to come back for that, I do have some time tomorrow afternoon. I do have some time today if you need that.
For the
Indigency.
I think I can remedy that.
Okay.
What I'm gonna do is, I'm gonna give it to the state for them to look at an order that basically says I can sign for her for this application only. I don't know if there's any problem with that.
Well, we don't object to your order. I don't know if it's sufficient for the clerk. However, it should be noted that Ms. Cook has spent the last 6 years of her life in custody, and I don't believe she owned a home she was renting. We know that from the facts of the case. I can't see how anyone could not find her indigent under the circumstances she's in.
I'm telling you, Your Honor, as a defense attorney who's done this, including with 6 DCA, the problems I run into, I don't want to say idiocy, but they want an application. The old one will not do. I've gone through this many times and doing it right now for another case. I'm just asking to be, so that there's something in the record that I'm signing for her. It's not under false pretenses, and the clerk of the court can recognize my signature in lieu of her. That's all I'm asking, so we can get that appellate process go through.
I am well aware of the appellate process for you, Mr. Gorgian. I have no problem signing off on an order that you can do that. I would agree with Ms. Marzano. Ms. Cook has been in custody for the last 6 years. She doesn't have any possessions in which to not be indigent, so it doesn't make sense that she would not be determined to be indigent. I'm putting it on the record as well, Mr. Gorgian, on the off chance that helps. If it doesn't, and we need to do something different, they'll let us know and we'll draft.
And the reason why I'm doing this now, because the application comes in way after I filed the statements, all the other pleadings from the court reporter to the clerk. The final 2 documents are the motion for indigency and the motion to withdraw and the motion to defend. That's why it comes at the end, Your Honor.
And again, I am well aware of the procedures application, so you're gonna provide the application. Whether or not it gets accepted, that's a different issue.
Well, wait, that's the whole point. I mean, I don't wanna come back and waste court's time.
I don't want you to,